Be ready for the dictation. 5 seconds to go. The Supreme Court examined the scope and ambit of powers of the High Court under Section 482 of the Code in quashing of the criminal proceeding in non-compoundable offences relating to matrimonial dispute and held in paragraphs numbers 15 to 17 as under. In our view, it is the duty of the courts to encourage genuine settlements of matrimonial disputes, particularly when the same are on considerable increase. Even if the offences are non-compoundable, if they relate to matrimonial disputes and the court is satisfied that the parties have settled the same amicably and without any pressure, we hold that for the purpose of securing ends of justice, Section 320 of the Code would not be a bar to the exercise of power of quashing of FIR complaint or the subsequent criminal proceedings. There has been an outburst of matrimonial disputes in recent times. The institution of marriage occupies an important place and it has an important role to play in the society. Therefore, every effort should be made in the interest of the individuals in order to enable them to settle down in life and live peacefully. If the parties ponder over their defaults and determine their disputes amicably by mutual agreement instead of fighting it out in a court of law, in order to do complete justice in the matrimonial matters, the courts should be less hesitant in exercising its extraordinary jurisdiction. It is right to state that the power under Section 482 should be exercised sparingly and with circumspection only when the court is convinced on the basis of material on record that allowing the proceedings to continue would be an abuse of the process of the court or that the ends of justice require that the proceedings ought to be quashed. We also make it clear the CPC has been amended to introduce several provisions such as those relating to limiting unnecessary adjournments and imposition of costs for the same, for ensuring that trials in civil cases are concluded in an expeditious manner. However, these provisions are not being strictly adhered to by courts, leading to delays in court proceedings. Proper training and sensitization of judges on these issues can help in achieving better implementation. The indiscriminate use of writ jurisdiction and multiple levels of appeals also leads to delays in the final disposal of cases. Currently, our litigation system is largely advocate driven rather than being driven by the courts. While on one hand, this needs to be addressed through proper training and sensitization of judges, on the other, there is also a need to bring about appropriate reforms in the bar. A robust regulatory mechanism to monitor the conduct of members of the legal profession will help in the proper implementation of the legal provisions aimed at expeditious disposal of cases. Certain types of cases, such as those pertaining to dishonor of checks under Section 138 of the Negotiable Instruments Act 1881 and Traffic challan cases under the Motor Vehicles Act 1988 form a large number of the pending cases before courts. Bringing about appropriate amendments to these legislations to address such cases can help in reducing the burden of courts.